Welcome to tonight's episode of Student at Law, where the relevant questions in law gets answered. Tonight we will be discussing the principles of evidence and procedure, in particular relevance, credibility of witnesses, expert witnesses, and background character. We have with us two special guests. Mr. Hickey and Mr. Green are both criminal defense barristers. They will be talking about some of their experiences in court relating to the competence of witnesses, admission of evidence, and cross-examination of witnesses. On to our first guest, Mr. Hickey. You're here to talk about the issues that may arise when a child gives evidence in court. Please share with our listeners at home some of the potential issues.
Thank you for having me on the show. First off, the giving of oral evidence in court by witnesses is a key feature in our adversarial system. In some cases, there will be children involved. Children, especially in cases of sexual assault, are particularly vulnerable. The law recognizes this and thus affords them some extra protection. For example, Section 15YJ of the Crimes Act 1914 requires child witnesses to give evidence through CCTV. The aim of this provision is to not re-traumatize the child and to also minimize contact between the victim and accused, because as we know, children's psyches are not as fully developed as compared to adults.
By that, do you mean in terms of thinking capacities?
Yes. As mentioned, the law treats a child as a vulnerable person. As such, children are subject to the same procedures as other vulnerable persons, and the first step is to determine the competence of them giving evidence about a fact. Usually, the most difficult part involving children is whether a child understands the concept of giving sworn evidence. The common law test to determine a person's competence in giving sworn evidence is whether the person is capable of understanding that he or she is under an obligation to give truthful evidence. Each child's capacity to understand is determined on a case-by-case basis and may involve expert evidence.
On the subject of competence, can you tell us what affects competence and why is it important in giving evidence?
Mental, physical, and intellectual capacities are all considered in determining competence. If it is determined that the child is not competent to give evidence, the child cannot be admitted as a witness. Thus, any evidence the child gives is set aside by the court.
It seems that competence is a big issue when children are involved. It seems natural, then, that the reliability of a child as a witness will be a subsequent issue, and following that, their credibility as a witness as well.
Yes, unfortunately, you are correct. There is very strong public prejudice against children giving evidence in court. In fact, this prejudice is so strong that the sections 165 to 165A of the Evidence Act are necessary to emphasize the point that a child's evidence should only be deemed unreliable if there are strong reasons to do so, and not just based on their age alone.
Section 42 of the Evidence Act states that unless the court disallows a question, a party may ask a leading question to a witness in cross-examination. Can we assume that a child witness's limited capacity would affect their ability to answer questions in cross-examination? And if so, are there any safeguards?
Cross-examination of a child by the defense counsel, especially in sexual assault cases, is an ongoing issue. Even with the protection already provided to the child, there is a clear power imbalance when the defense counsel starts asking questions to the child during cross-examination. While sections 41 and 42 of the Evidence Act allow the court to intervene in certain situations, such as when improper or leading questions are asked, the child is still largely exposed to the defense counsel. The defense counsel's job is to create reasonable doubt in a criminal case, and by asking the child questions in a complex manner, this is quite easily achievable. Confusing the child into making inconsistent statements portrays to the jury that the child may not be telling the truth, and thus may also hurt their credibility as a witness. On the topic of credibility, while evidence solely relevant to credibility cannot be adduced, cross-examinations fall under one of those exceptions. A witness can be questioned in cross-examination on the credibility issue if it has substantial probative value to the credibility of the witness. Since credibility is always an issue in sexual assault cases, the child will unfortunately be subject to a long cross-examination by the defense, where the process itself will most likely be a traumatizing experience for him or her, notwithstanding the crime itself and the investigation leading up to the court case. While they are entitled to having a support person present to help them, this may still be insufficient for the welfare of the child.
This reminds me of a case I recently observed in court for an assignment. Are you familiar with the recent trial of R.V. Nesahauda?
Yes, I am. That case is unique in the sense that a judge must try to balance the rights between a deaf and mute accused against those of a 13-year-old child. I am following it closely.
During the trial, the child witness was noted to give prior inconsistent statements. Can that be attributed to how cross-examination was conducted?
In a way, yes. As mentioned earlier, the child can easily be confused by asking complex questions. Judges must be more aware of this and try to intervene as much as possible as to attain the best possible response from the child through the power not only afforded by the relevant sections of the Evidence Act, but also in Section 15YE of the Crimes Act. However, this must be balanced against the basic principles of natural justice. It is admittedly a difficult exercise, complicated further by the disabilities of the accused. It should be noted that the defendant's main argument is he had an honest and reasonable belief that the victim was at least 16. Inherent in that defense is that he must establish the child was lying about her age. Thus, her credibility will foreseeably be an issue, and so will the problems regarding cross-examination.
Thank you so much for your valuable insight. We hope to have you on next time. Moving on, we have Mr. Green, who will be sharing with us the impact of evidence given by expert witnesses. Hello Mr. Green, welcome to the show.
Thank you for having me on today's show. The use of expert witnesses are given special mention in Section 108C, whereby it states that there is an exception to the credibility rule with regards to evidence of persons who have specialized knowledge based on their training, study, or experience. Particular emphasis is placed on the specialized knowledge of child development and behavior, with reference to the impacts of sexual abuse as per subsection 2.
Can you then tell us what practical applications does this subsection have in terms of witness credibility?
Practically, this allows the counsel to call forth such experts to provide justification or validation to the evidence of other witnesses. For example, in the case of R.V.F. Dmowski, the defendant was accused of rape. His defense was that the sex was consensual and that the consent can be inferred from the prior conversations through text messages. The intriguing part about this case is that both parties in the present case are of Macedonian descent, and the text messages were all in their native language. According to the defense, direct translation of the messages is not sufficient to give full context of their affiliation, and as such, the defense counsel chose to employ the use of a Macedonian linguist expert as a witness to give evidence and perspective on the nature of the text messages. By having a linguist expert, the defense hopes to give credibility to the accused's claims of consent by both parties. Whereas in the case of Hauda, a child psychologist was summoned by the defendant to place further doubt into the credibility of the child's evidence, as it was deemed that the psychologist had high probative value.
That is indeed an interesting way of using an expert witness. How effective was the expert in establishing or diminishing credibility?
The linguist expert, for the most part, did not provide much additional insight to the text messages and only served to rehash what the defense was saying, in the sense that he agreed or disagreed in accordance with what the defense wanted to establish. The cross-examination was also carried out swiftly, as there was nothing substantial to dispute. Personally, I feel that the use of an expert was not suited for this case. It did not change the jury's perception towards the accused in any way, and as such constituted a waste of resources for everyone involved.
How do you think such witnesses can be properly utilized then?
An expert should be summoned when the evidence given provides meaningful insight and an informed view of which would allow a more definitive perception to be formed of a witness' credibility. For example, their experience and knowledge of a coroner would be very important in validating a witness's testimony in a case involving fatalities. Similarly, the examination-in-chief and cross-examination of the child psychologist in Hauda's case was extremely thorough, as the decision may very well hinge on the evidence she gave. This is especially relevant as the defense aims to utilize her troubled family background and tendency to lie to further diminish the victim's credibility.
I see. So how should the defense go about improving the credibility of the accused in F. Dmowski?
More commonly seen for the defense of the accused is the utilization of Section 110, which provides that the hearsay, opinion, tendency, and credibility rule does not apply for evidence adduced to prove the good character of the defendant. In F. Dmowski, the defense counsel relied on Section 110 by summoning 4 friends of the accused to adduce evidence to prove that he is generally, or in a particular respect, a person of good character. This was established from the beginning of proceedings, as to conform with the judgment in Bartle, where it was decided that the defense must cite evidence with a positive intention to prove that they are of good character.
Were all the testimonies given accepted, or are there strict rules governing the admissibility of such evidence?
There is no obligation for the judge to direct the jury concerning the defendant's good character. In the case of Melbourne, it was established that it is preferable to leave discretion with the judge as to whether direction on evidence of good character should be given, after evaluating its probative significance and credibility.
So how did the judge go about in this present case? And in your opinion, was this more effective than summoning the expert witness as previously mentioned?
The judge did not provide much external input during the examination and cross-examination of these witnesses, and allowed the questioning to flow without much interruption. Most first-time offenders would take advantage of Section 110, as it is relatively easier to prove good character when there is no official prior records to prove the contrary. Having said that, it is still important for the prosecutors to find any inconsistencies in the witnesses' statements, ensuring that this advantage is not grossly misused. Nonetheless, I feel that Section 110 serves as a reasonable advantage for the defense, in line and working well with the fundamental legal principle of innocent until proven guilty.
Thank you, Mr. Green, for sharing with us all these interesting issues. Unfortunately, due to time constraints, we have come to the end of tonight's show. We hope you enjoyed the material we have covered. Till next time, this is Student at Law.